Hello students, welcome again. Today again we will start with our leftover chapter, different kinds of contract. We already seen that there are different kinds of contract on the basis of validity, on the basis of formation, and on the basis of performance of the contract. I already introduced you to the different kinds of contract on the basis of validity. Today we are going to see the different contracts on the basis of formation. On the basis of formation, the contracts can be classified as express contract, implied contract, quasi or constructive contract. Firstly, express contract. An express contract is one entered into by words, either spoken words or the written words. Means which is expressly stated that we are going to enter into a contract, either by word spoken or by word written on a paper. So where a proposal or acceptance is made in words spoken or written, the proposal or acceptance and ultimately the contract will be called as a express contract. Next is implied contract, where a proposal or acceptance is made otherwise than by words spoken or written, it will be treated as an implied contract. Implied contract can be smelled out through the surroundings of the circumstances and the conduct of the parties who made them. So we have to look at the surroundings of the contract and then only decide whether there is a contract or not. So where a person employs another person to do some work, he has to pay for that work. So it is an implied contract. We don't need to put it in writing or we don't need to say it in words. So it is an implied contract. Another example, I have already told you that whenever you go to the hotel and order a cup of tea, ultimately you have to pay for that cup of tea. So it is an implied contract. You don't need to say in words that you are going to pay for it. It is assumed that you are going to pay for it. But in case of express contract, you have to express those in words. Next is quasi or constructive contract. It is a contract in which there is no intention by both the sides of the parties to make the contract, but the law imposes that contract. I will give you an example. Suppose you found a watch on the street. What do? You pick that watch and put it in your pocket? No. Normally we don't do that. We try to find out who is the actual owner of that watch. And then we try to return it to that actual owner. So whether there was the intention in your mind to enter into contract with that person, no. But you enter into a contract with that person to return that watch as it is, as it was found by you to that person. So in such contracts, rights and obligations arise not by agreement between the parties, but by operation of law. So here the law applies directly. Without intention of the parties enter into a contract. Thus, a finder of a lost goods is under an obligation to find out the true owner and return the goods. Similarly, suppose certain goods are delivered to the wrong address, you have to return those goods or return those books, or you have to pay for those books. Nextly, classification on the basis of performance. On the basis of performance, the contracts can be classified as unilateral contract, bilateral contract, executed contracts, and executory contracts. Unilateral contract, it is the one in which the promise on one side is exchanged for the act of other side. So one party promises to do something and other party promises some payment. Example, whenever we go to the doctor treats us, examines us, and then we pay him the fees. So such contract, one party to the contract has already performed his part of promise or obligation, and the other party is still to perform their part of promise. Next is bilateral contract. In such a contract, a promise on one side is exchanged for the promise of other side. It means both the parties are yet to perform their part of promises. So in such contract, obligation from both the parties is still pending. Example, A promises to paint a picture and B in return promises to pay rupees 500. So here, painting a picture is still pending and paying the amount is still pending. So both the parties are yet to perform their part of promises. Hence, we can call both the parties as a promiser and promisee. So both the parties are here promiser as well as promisee. Next is executed contract. A contract is said to be executed when one party to the contract has performed his share of obligation, another party is still to perform his part of promise. Example, A advertises a reward of rupees 25 to anyone who finds his missing dog. So another person B finds out his missing dog and brings it to A. Here, B has already performed his part of promise. Now, A has to perform his part of promise. So, in this, one party has already performed their part of promise and the other party is yet to perform their part of promise. Lastly, the executory contract. It is a contract where some future act is to be done. It is one which is either wholly unperformed or there remains something to be done by both these parties. Means either of the party has to perform their part of promise in full. So, example is building a house property. At the time of entering into contract of building a property, we enter into such a kind of contract that suppose first part is completed, then we will pay the amount. Second part is completed, then we will pay the amount. So both the parties are yet to perform their part of promises. So it is an executory contract. First party has to perform something, then second party will perform something. So it is an executory contract in which both the parties are either wholly unperformed or there remains something to do to be done by one of the parties or both the parties. So that's it, friends. Here, the different kinds of contracts aims. Don't forget to like, subscribe, and share our YouTube channel, Zanai Coaching Academy. Thank you.